Please be seated. Sitting is open. We start today the hearing of the first round of pleadings by Chile. And now I give the floor to the agent of the government of Chile, Mr. Claudio Grossman. You have the floor, sir.
Thank you. Mr. President, the members of the court, it is an honor to appear before you as agent of Chile. I would like to take this opportunity to acknowledge the presence of Chile's Minister of Foreign Affairs, Roberto Ampuero, as well as other government officials, members of the Chilean Senate and diplomatic corps, and respectfully to greet our Bolivian counterparts, including Bolivia's Foreign Minister, Fernando Guanacuni. Just as Bolivians are carefully following these proceedings, the Chilean people, too, are glued to their television and computer screens and reading in earnest, minute by minute, press report about what is happening in La Haya. Mr. President, Chile held its 7th free and fair elections since the return of democracy in 1990. On 11 March, our new president, Sebastián Piñera, and our new Congress were sworn in. We are proud of Chile's deep commitment to the rule of law, the separations of powers, and an independent judiciary. Chile aspires to empower its people by respecting the rights and freedoms of and creating opportunities for all its citizens. Chile's active engagement in the international community is marked by its respect for and dedication to international law, peace, human rights, and bilateral and multilateral cooperation. Chile is a proactive member of the United Nations, and despite its relatively small population and geographic location, it has contributed peacekeepers to operations all over the world. Chile's vocation for peace and the peaceful resolutions of international disputes is further reflected in its service in the historic peace accords concluded between the government of Colombia and its main armed opposition in September 2016. Chile has ratified almost every human rights treaty and actively participates in regional and global international organizations to address cooperatively matters of common concern to humanity, taking a leading role in the protection of the oceans, the fight against climate change, and the promotion of sustainable development. Chile is proud of its active membership in regional organizations dedicated to cooperation and integration, including the Organization of American States, the Union of South American Nations, the Community of Latin American and Caribbean States, and the Pacific Alliance. Only a few days ago, Chile and 11 other countries signed the Comprehensive and Progressive Agreement for Trans-Pacific Partnership in Santiago. Mr. President, members of the court, Chile and its neighbors have lived in peace for more than a century. As you know, in 1904, Chile and Bolivia concluded a treaty of peace and amity, which fully settled all outstanding territorial issues between our two states. Under these treaties, the two states agreed on the complete boundary between them. Chile also recognized in favor of Bolivia in perpetuity the fullest and most unrestricted right of commercial transit in its territory and its Pacific ports, as well as other privileges and benefits, including the construction of railroads, vital to its development at that time. Let me be absolutely clear. The Treaty of 1904 constitutes the full agreement consented to by Chile and Bolivia. There was no historical bargain outside the scope of the 1904 treaty. Instead of a wall, as Bolivia would have the court believe, the 1904 Treaty of Peace and Amity is a freely agreed bridge linking our two peoples. It is the bedrock of our bilateral relationship, and through subsequent agreements involving trade, migration, and cooperation, Chile and Bolivia have built upon its solid foundation. As guaranteed by the treaty, Bolivia enjoys unrestricted access across Chilean territory in transporting goods in both directions. The main port used by Bolivia is in Arica. In recent years, almost 80% of the cargo in Arica's port was Bolivian. Bolivia enjoys important storage benefits and no custom duties in Arica and Antofagasta. And Chile has offered to Bolivia free transit facilities in the port of Iquique. Bolivia has not taken up Chile's offer to utilize Iquique's facilities. In fact, Chile has done much more than what is required by the treaty. In recent years, Chile built 3 new border complexes, enlarged and improved routes connecting Bolivia with the ports of Arica, Iquique, and Antofagasta, and improved the port facilities in Arica by increasing the total storage capacity fourfold at a significant cost to Chile. Bolivia is one of the few countries in the world to operate its own custom authority in another country's ports. The legal regime established in the 1904 Peace Treaty, including Bolivia's access to the sea, is unaffected by any political changes in either country. Yet Bolivia is not satisfied with perpetual and free access to Chile's ports. It wants to change the nature of its access to the sea from what it freely agreed to in 1904. Bolivia wants Chile to cede Chilean coastal territory to Bolivia, undisputed territory over which Chile has exercised continuous sovereignty for over a century, including in this territory is Arica and Parinacota, a region where 300,000 Chileans live and work. Bolivia wishes to revise both the history of a 19th century war and the 1904 Peace Treaty. In other words, although it purports to present a case consistent with the court's judgment in 2015 on the preliminary objection, in reality, Bolivia ignores it. The court made clear that this case is neither about the legal status of the 1904 Treaty of Peace and Amity, nor about an obligation of result. Instead, the subject matter of the dispute is whether Chile is obligated to negotiate in good faith Bolivia's sovereign access, and if so, whether Chile has breached that obligation. Bolivia has made a claim to the court in terms it knows will not succeed, and then it has changed its case at every opportunity in the hope of attaining anything at all. But the fact remains that its claim is unsustainable and it must be dismissed in its entirety. Bolivia misstates and misrepresents both the facts and the law. First, as we have explained in the written pleading, Bolivia's violation of the terms of the 1874 treaty and its refusal to solve that dispute through arbitration were the true causes of the War of the Pacific, along with Bolivia's arbitrary collective expulsion of Chileans and seizure of their property. Chile reminds Bolivia that the court is not charged with adjudicating the history or outcomes of the War of the Pacific. Second, Chile adamantly rejects and is disappointed by Bolivia's characterization of Chile's behavior. It is Bolivia that repeatedly broke off negotiations and terminated diplomatic relations with Chile. Chile has willingly engaged in diplomatic exchanges and bilateral discussions with Bolivia. It has at different times and in different ways and motivated by different considerations sought to engage with Bolivia's aspirations and desires for improved access to the Pacific coast. But the willingness of a state to engage in a diplomatic dialogue with its neighbors does not create a legal obligation to negotiate, let alone to reach an agreement. None of the encounters between Chile and Bolivia was based on the existence of a legal obligation to negotiate. Third, and as already decided by the court, the 1904 peace treaty is not and cannot be at stake in these proceedings. Chile's sovereignty over all the land territory that lies between Bolivia and the Pacific Ocean was settled fully and in perpetuity in 1904. It follows that Bolivia has no right to its territory, and the court's preliminary objections judgment proceeds on the basis that Bolivia is not claiming such right. As Bolivia is fully aware, Article 6 of the Pact of Bogota excludes from the court's jurisdiction matters already settled by arrangement or governed by treaties in force in 1948. Bolivia has framed its case as one based on an alleged obligation to negotiate sovereign access. But exactly what Bolivia means has changed materially in the course of this case, including in its presentation this week. Bolivia's latest efforts to reopen the 1904 settlement is grounded in broad claims of historical injustice. But doing justice cannot mean asking the court to step aside its judicial role or ignoring this court 2015 judgment or treating Chile as an isolationist villain on the basis of entirely untested and misleading accusations. Bolivia's case is neither simple nor modest as its counsel asserted earlier this week. Bolivia has presented multiple iterations of its case, each of which suggests a considerable lack of confidence in the case as previously put. In its newest and most extreme version, on Monday, Bolivia attempted to ground an obligation to negotiate the cession of sovereign territory in membership of the Community of Nations. This proposition is dazzling in its implication for international relations. It is also striking in the lack of faith that it suggests in Bolivia's case on the existence of an actual agreement unilateral statement, or other form of conduct establishing an obligation to negotiate. Bolivia's acrobatics belie its true intentions. Bolivia asked the court to find that Chile is under a legal obligation to negotiate with Bolivia in order to reach an agreement granting Bolivia a fully sovereign access to the Pacific Ocean. While in its oral pleadings on Chile's preliminary objection in 2015, Bolivia retreated from the claim of an obligation of result to one of conduct. In its subsequent pleadings, it continues to assert that Chile has an obligation to negotiate to reach an agreement granting Bolivia sovereign access. Despite Bolivia's machinations to retain jurisdiction at the preliminary objections phase, it is now clear that when Bolivia says sovereign access, it means cession of territory. What Bolivia is seeking from the court is a mandated negotiation to reach an agreement ceding Chilean sovereign territory to Bolivia. In Bolivia's view, this duty to negotiate is infinite in duration, never extinguished until Bolivia gets the specific result it wants. There is no sound, legal or factual basis for any such duty in any document or statement that Bolivia has pointed to or its new case founded in general international law. Outside the Peace Palace, Bolivia has spoken more freely about its true motivation. It has confirmed that it is here to implement the imperative set out in its 2009 Constitution, which proclaims Bolivia, quote, unwaivable and imprescriptible right over the territory giving access to the Pacific Ocean and its maritime space, end quote. The Constitution also required the executive to denounce or renegotiate treaties that are contrary to the Constitution. In 2013, the Bolivian Senate said that the constitutional duty to denounce and renegotiate treaties could be fulfilled by utilizing international tribunals to challenge those treaties. Just 2 months later, Bolivia filed its application with the court. It is the constitutional mandate that is the real origin of this case, not any conduct by Chile. If any doubt remains about Bolivia's true intention, one need only look to the words of its own president only 3 days ago, who announced to the world that Antofagasta, quote, was, is, and will be Bolivian, end quote. Mr. President and members of the court, 700,000 Chileans reside in Antofagasta, a territory over which Chile has exercised sovereignty for over 114 years. In its presentation over the next 2 days, Chile will address what remains of Bolivia's case, a case remarkable free of analysis of either facts or law. Simply listing the dates of documents or selectively quoting and distorting language out of context cannot satisfy Bolivia's burden to prove its case. Today, Sir Daniel Bethlehem will provide an overview of the elements of Chile's case. Professor Jean-Marc Touvenan will then address the legal principles relevant to Bolivia's case. Then Dr. Kate Parlett will demonstrate that no obligation to negotiate sovereign access arose on the basis of diplomatic events between 1920 and 1929. Finally, Mr. Samuel Wordsworth will begin a discussion of the diplomatic notes of June 1950 and Bolivia's case that disestablished an international agreement to negotiate sovereign access, completing these remarks tomorrow. Tomorrow, Mr. Wordsworth will also examine the Charaña process of 1975 to 1978 in more detail than Bolivia ventured, demonstrated that this did not create or confirm any legal obligation to negotiate and that the failure of the negotiation was squarely due to Bolivia. Professor Monica Pinto will show that the political statements and resolutions of the Organization of American States during the 80s and the conduct of the relevant states created no legal obligation to negotiate. She will emphasize that the OAS General Assembly has adopted no resolutions on this topic for the past 3 decades. Dr. Ben Juratovich will then demonstrate that no obligation to negotiate persisted or arose following Chile's return to democracy in 1990. Finally, Professor Harold Koh will conclude Chile's presentation by emphasizing that ordinary diplomatic exchanges between neighboring states cannot be converted into sources of a legal obligation to negotiate. Such an approach would discourage the peaceful resolution of disputes by diplomatic means. Mr. President, members of the Court, Chile is proud of its record and reputation as a collaborative and thoughtful voice on the challenges that face our world. Chile wishes to reiterate, however, that it has never had any legal obligation to negotiate the cession of its territory and sovereignty to Bolivia, and has no such obligation today. Thank you for your kind attention, Mr. President, and I ask you to give the floor to Sir Daniel Bethlehem.
I thank the agent of Chile, and I now give the floor to Sir Daniel Bethlehem. You have the floor, sir.
Good morning, Mr. President, Madam Vice President, members of the Court. It is an honor to appear before you today and before the Court in its new composition to represent Chile in these proceedings. My submissions will be divided into 4 parts. I would like first to make a number of points of immediate response to what we heard from Bolivia earlier in the week. Our submissions will be responsive, and I will start the process of engaging with what Bolivia has said. I will also pick up on some of the themes identified by Chile's agent just a moment ago. Following this, I will look at the bigger picture. Bolivia would like you to see some things, but not others. We think a more balanced perspective is necessary, and I will identify a number of elements that we think should properly inform the prism through which you look at this case. Third, I will return to Bolivia's case and make some further observations about its claimed historical bargain. And finally, by way of conclusion, there is a brief point that warrants comment concerning an argument that Bolivia did not make earlier in the week. Mr. President, members of the Court, I start with 6 points of immediate response to the case we heard from Bolivia early in the week. The first point is that it is quite striking that Bolivia is saying that every form of engagement between states creates a legal obligation to continue to engage, and that once created, that obligation to engage never ever goes away. Professor Ramiro Bertons put it most directly on Tuesday when he said, one state, when it formally requests negotiations on a matter and another state responds, that latter state is bound by an obligation to negotiate that it cannot disavow. This proposition was echoed in the submissions of other Bolivian counsel. Mr. President, members of the court, this is a quite remarkable proposition. And when you put it together with Professor Lowe's case on Article 2.3 of the UN Charter, it would formalize and constrain diplomacy in no one's interest. And it is also wrong in law, as it bypasses the very essence of what is required for a state to be subject to a legal obligation, and namely, an intent to be bound, whether express or implied, whether by act or by representation. My second point, equally striking, goes to Professor Forteau's concluding observation on Tuesday that Chile is attempting to drown the court in a flood of details. This is quite remarkable. Bolivia is here as the claimant, requesting the court to order Chile to engage in negotiations with the outcome of ceding sovereign Chilean territory to Bolivia. To this end, Bolivia asks the court to imply a legal obligation to negotiate and to constrain Chile, to stop Chile from maintaining the contrary. Yet in almost 6 hours of submissions at the beginning of the week, Bolivia did hardly more than give you a soundbite from 1 or 2 documents in support of its case. And indeed, Professor Lowe suggested that you could reach a conclusion that Chile was legally bound to negotiate without regard to any conduct of the parties, simply by reference to Article 2.3 of the UN Charter. While Professor Ramiro Bertons and Ms. Sander referred you to some documents, they did so at a very high level of abstraction. And essentially, we are left with the appreciation that Bolivia's entire claim was built on assertion and on generality, rather than on evidence and on proof. Mr. President, members of the court, if there is a divide between the parties on what is required to reach a reasoned and considered judgment in this case, it is on this very point. We are here before a court of law. Indeed, we are here before the court of law in the international community. Bolivia is alleging a legal obligation to negotiate on Chile's part to secure what Professor Forteau described as a definitive solution of a cession to Bolivia of sovereign Chilean territory. Mr. President, members of the court, it behooves Bolivia to come to the court with details to prove its case, but it has done nothing of the sort. It rests its case on a flawed sense of historical injustice, rooted in Professor Chemelier-Gendreau's partial vision of a blood-soaked history made current. This is not the law. Mr. President, members of the court, Chile comes to the court with a case that rests on the evidence. Bolivia has failed to engage with that evidence. This case cannot properly be decided by reference to entreaties to sentiment. It is a case about law, and it is on Professor Forteau's much derided detail that a fair judgment will need to be founded. My third point of response is to draw attention to change and discordance in Bolivia's case. The change is the changing character of Bolivia's case, the 4th iteration of which we heard this week. Bolivia began its case with a claim of a right to sovereign access to the Pacific Ocean. As stated in its memorial, Bolivia, quote, is in a unique and unprecedented position. It has been landlocked for more than a century while retaining a right of sovereign access to the sea that it has not been allowed to exercise, close quote. The same point is made elsewhere in the memorial. Now, this claimed right of sovereign access was the foundation of Bolivia's prayer for relief. And you should see a slide on the screen quoting the prayer for relief, which remains unchanged. This is from the reply. The prayer for relief asks the court to adjudge and declare that Chile must perform the said obligation to negotiate, quote, to grant Bolivia fully sovereign access to the Pacific Ocean, close quote. Now, Mr. President, members of the court, the prayer for relief has been the one constant in Bolivia's case. It asserts an obligation of result, an obligation to negotiate to secure a specified outcome. In its oral pleadings at the preliminary objections phase, Bolivia's case underwent a change. To defeat Chile's contention that Bolivia was trying to unsettle something that had been settled by the 1904 treaty, Bolivia recast its case as one of an obligation of conduct, an obligation to negotiate in good faith rather than an obligation of result, as well as advancing a new theory of what was meant by sovereign access. Now, Mr. President, members of the court took Bolivia at its word and concluded in paragraphs 32 and 33 of your preliminary objections judgment that Bolivia does not ask the court to adjudge and declare that Bolivia has a right to sovereign access. As determined by the court, the subject matter of the dispute with which you are seized concerns whether Chile is under an obligation to negotiate sovereign access to the Pacific Ocean. This excludes the question of whether Bolivia has a right to sovereign access. Indeed, the court stressed that even assuming arguendo the existence of an obligation to negotiate, quote, it would not be for the court to predetermine the outcome of any negotiation that would take place in consequence of that obligation, close quote. The court determined at the preliminary objections phase that the subject matter of the dispute of which you are seized concerns the existence of an obligation of conduct, not an obligation of result. Now, Bolivia's case changed focus again in its reply. The primary focus of the memorial on claims of express and implied commitment by Chile to negotiate ceded center stage to a case that rested heavily on claims of estoppel, legitimate expectation, and acquiescence. The reply also saw an attempt to bring the case back to a claim for an obligation of result, following the expedient abandonment of this claim for purposes of the preliminary objections proceedings. And we then come to the case presented earlier this week and a new theory advanced by Professor Lowe based on Article 2.3 of the UN Charter. While there is passing reference to Article 2.3 in Bolivia's reply, although no reference in its memorial, the theory advanced on Monday by Professor Lowe was entirely novel. The court, we were told, need not have regard to any evidence of conduct by the parties for purposes of founding an obligation to negotiate, because such a change is to be found in Article 2.3 of the UN Charter. And Ms. Sander echoed Professor Lowe's submission by reference to Article 3 of the OAS Charter. That is change. Turning to discordance in Bolivia's case, this was evident in the argument advanced through the voices of Bolivia's different counsel. With almost one voice, Bolivia's agent and Professors Acavan, Chemelier-Gendreau, Ramiro-Bretons, and Forteau spoke of an obligation of result. As expressed by Professor Acavan in opening Bolivia's case, quote, Chile is under a binding obligation to negotiate an end to Bolivia's landlocked situation, close quote. The outcome is predetermined, only the modalities remain to be addressed. As expressed by Professor Forteau in closing, Bolivia asked the court to order a definitive solution that Chile must negotiate to secure Bolivian sovereign access to the Pacific Ocean. And concordant submissions were made by Bolivia's agent and by Professors Chemelier-Gendreau and Ramiro-Bretons. Now, Professor Lowe, however, was singing from a different hymn sheet with the support of Ms. Sander. Professor Lowe's submissions were all about an obligation of conduct, not an obligation of result. He spoke about a duty to receive communications, a duty to consider proposals, etc. And he expressed surprise that Chile was reluctant to entertain such a modest proposal. Now, what are we to make of this change and discordance in Bolivia's case? In the first instance, it is important simply to recognize the mercurial character of Bolivia's case and draw pause for thought from this. Professor Acavan began Bolivia's submissions on Monday by extolling the simplicity of Bolivia's case. Professor Forteau concluded Bolivia's case on Tuesday by echoing this intonation. But Bolivia's case is not quite so simple. And it is not that Bolivia is struggling to articulate its case. Our friends on the other side of the room are very articulate. It is not that Bolivia's case rests on complex evidential detail. They have carefully shied away from such detail. Rather, it is that Bolivia is simply making up its case as it goes along. Its case changes shape at every attempt to grasp it. We still do not know when the claimed obligation to negotiate came into being. We still do not know whether Bolivia is seeking an obligation of result or whether Professor Lowe has more modest aims, even if dressed up in very big clothes. In Chile's submission, this undefined quality to Bolivia's case should cause the court to hesitate long when it comes to assessing Bolivia's claims. A case that claims a legal obligation on the part of another, however it is packaged, concerning a cession of territory, must be held to a high standard of proof. This is not likely to be presumed, nor can weight without more properly be given to Bolivia's assertion of bona fide reliance on what Bolivia says Chile has committed itself to, but which Bolivia struggles to define and fails to prove. So what exactly is Bolivia's case? Does Bolivia claim an obligation of conduct, or does it claim an obligation of result? If it claims an obligation of result, following the court's preliminary objections judgment, this is simply outside the jurisdiction of the court. If it claims an obligation of conduct, Bolivia must present a case on the facts by reference to the legal character of such an obligation. Now, Mr. President, members of the court, on Monday, Professor Lowe referred you to the commentary of the UN Charter edited by Bruno Simmer and cited extracts which were included at tab 16 of Bolivia's hearing bundle to support his contention that Article 2.3 of the Charter had legally binding effect and gave rise to an obligation to deploy active efforts for the settlement of an international dispute. But he failed to take you to the following paragraph on his extract at tab 16, and that says the following, quoting from Simmer, quote, "It should be noted that Article 2.3 obligates states to strive for the resolution of a dispute existing between themselves only to the best of their abilities. The obligation enshrined in Article 2.3 must not be mistaken for an obligation to reach a specific substantive result." That's Simmer on the UN Charter. Now, obligations of conduct are not obligations to reach a specified substantive result. Bolivia has no right of sovereign access. This issue is not before the court. There is no proper basis on which Bolivia can sustain a claim for a declaration by the court that Chile is required to negotiate, quote, effectively to grant Bolivia a fully sovereign access to the Pacific Ocean, close quote. And as to the claimed obligation of conduct, there is no case on the facts before you to sustain the existence of such an obligation. Mr. President, members of the court, my fourth point concerns the substance of Professor Lowe's argument on Article 2.3 of the UN Charter. In setting out his case, Professor Lowe spoke about the modesty of Bolivia's case. Now, there was indeed modesty, but this is to be found in the economy of Professor Lowe's characterization of the issues, an economy that, like a magician's distraction, masked a sleight of hand. Professor Lowe spoke about the court remedying injustice extra legem, a 19th century historic injustice that Bolivia now claims for purposes of founding his case. In his appeal to the court to provide the tools to facilitate a settlement of disputes, he painted a tantalizing picture of how much better the world would be if only the court would seize the opportunity presented by Bolivia's case. Now, Chile would like a new world order as well, rooted in good neighborliness. And Chile has, on more than one occasion in the past, engaged with Bolivia in a spirit of good neighborliness, only to find that spirit dashed on the rocks of Bolivia's intransigence. The modesty of the Bolivian case that we heard about this week was not quite so modest. Bolivia is not saying we should make efforts to resolve our dispute please, Chile, come to the table and let's talk without preconditions. Bolivia is not saying all we are asking for is for Chile to come and talk and look for ways at overcoming our lingering dispute. Bolivia is saying something quite different. On the screen, you should see again Bolivia's prayer for relief. As will be plain from this, Bolivia imposes a precondition for the negotiations that it wants with Chile. Bolivia is not simply seeking good faith negotiations. Bolivia, rather, is demanding a pre-commitment from Chile to an outcome of sovereign access. There is also an additional consideration concerning Professor Lowe's new theory. From his submissions, it appears that the dispute that Professor Lowe has in contemplation when he invokes Article 2.3 is Bolivia's claimed 19th century injustice that it, quote, has been cut off from the sea by a forceful seizure of part of its territory, close quote. There is, however, a fundamental problem with this. That dispute, the dispute to which Professor Lowe refers, was without doubt settled by the 1904 treaty. The 1904 treaty drew a line under the War of the Pacific and gave effect to the injunction of the Truce Pact of 1884 that a definitive treaty of peace and amity would be concluded. The dispute that Professor Lowe invoked to sustain his Article 2.3 submission is thus a dispute that is undoubtedly beyond the court's jurisdiction under the Bogota Pact. My fifth point of response goes to the refrain that we heard from more than one of Bolivia's counsel. If Chile did not think that it was under an obligation to negotiate, Bolivia asks, why did it do so? This is a curious question, but perhaps it fits with Professor Ramiro Breton's proposition that you only respond to a request to negotiate from your neighbor if you intend to assume a legal obligation to continue to negotiate thereafter. Chile and Bolivia are neighbors. Chile would like to have good relations with Bolivia. Good neighbors talk. They find ways to talk even when there are difficulties. So at various points, Chile engaged with Bolivia, including on the issue of Bolivia's aspiration to sovereign access. But, Mr. President, members of the court, agreeing to talk is not the same as agreeing to be bound to talk. And importantly, Chile's motivation to engage with Bolivia was influenced by the factual circumstances and Chilean policy imperatives of each individual engagement. So, for example, as regards the June 1950 notes, Chile's engagement at the time was motivated by the possibility of reaching an agreement with Bolivia in which Bolivia would obtain sovereign access to the sea, but in return for allowing the waters of Lake Titicaca and other Bolivian lakes to be channeled for use in irrigation and hydroelectric power in Chile. In the same vein, within the Charaña process in 1975 to 78, while Chile was willing to negotiate, this was solely on the basis of an exchange of sovereign territory between the two states. Mr. Wordsworth will address both of these issues in greater detail. The bottom line is that Bolivia's question of why Chile engaged, if it did not consider itself bound to do so, does not have a one-size-fits-all response, save only that Chile never engaged with Bolivia out of a sense that it was legally bound to do so. Chile's engagement was motivated by good neighborliness. It was also motivated by its own policy imperatives that were circumstance and time-specific. And Mr. President, members of the court, as you will well appreciate, there is nothing unusual and nothing nefarious about this. This is what states do the world over for good and proper reasons and often to good and proper ends. Now, there is one other point to add on this, which goes to the unreality of Bolivia's appreciation of the negotiating dynamic that its conduct has engendered over the years. Not to put too fine a point on it, whenever Chile has engaged on Bolivia's sovereign access agenda and things have not unfolded as Bolivia would have liked, Bolivia has been adept at walking away. Bolivia has been adept at severing diplomatic relations. Bolivia has been adept at setting preconditions. And this is hardly the context in which Chile would have assumed or affirmed an obligation to negotiate. This is hardly the context in which Chile would have made representations to leave Bolivia on. Professor Forteau, in his closing remarks, referred to the 13-point agenda of 2006, and he said that both states knew exactly what they were doing. Well, he is exactly right. Both states knew what they were doing and indeed had a common understanding. That common understanding was a search for a new accommodation to their relations. To this end, the two states adopted a pragmatic approach that sidelined and downplayed the issue of Bolivia's sovereign access aspirations. There was a shared recognition by the two states that headlining an issue about which there was no immediate prospect of agreement could derail engagement on other issues. Dr. Djuratovich will address this in greater detail tomorrow. The bottom line is that after 1990, the engagement between Chile and Bolivia focused on practical initiatives. Bolivia may have retained its aspirations, but there was no engagement between the parties on the issue of a cession of sovereign territory, and no suggestion that Chile was bound by an obligation to negotiate. The focus was on other things. Now, my final point of response goes to Bolivia's invocation of history, and I will address Bolivia's claimed historical bargain more fully in a little later, but would like to make two headline points at this stage. The first is that there was no historical bargain in two parts, as Bolivia claims. The 1904 treaty drew a decisive line under the events of the late 19th century. It was by design, by name, by content, a definitive treaty of peace and amity, negotiated and agreed willingly and without let or hindrance on both sides as the anticipated outcome of the Truce Pact of 1884 that brought the Pacific War to an end. There was no second component of the 1904 settlement waiting in the wings, aimed at according to Bolivia sovereign access to the Pacific Ocean. The claimed existence of a two-part historical bargain is an ex post facto litigation construct by Bolivia that has no evidential foundation. Bolivia roots its historical bargain claim in a treaty, the 1895 Transfer Treaty, that never entered into force and was overtaken 9 years later by the 1904 treaty. The record shows that the then president of Bolivia considered the 1904 treaty to be a good deal. He campaigned for the presidency of Bolivia on that basis and was elected. It is, of course, the case that a number of his successors, including the current incumbent, have endeavored to revisit the issue, but to claim a two-part historical bargain is insupportable by reference to any informed appreciation of the evidential record. The second headline point goes to Bolivia's claim of historical injustice. Mr. President, members of the court, interpretations of history are for historians. Chile addressed Bolivia's misleading account of history in Chile's counter-memorial. Professor Chemelier-Gendreau, Professor Lowe, may want to press the court to right Bolivia's contemporary perception of its 19th century wrongs. The point, however, is that these proceedings are not a trial of dueling visions of the 19th century. Courts, of course, frequently assess and address history, and properly do so. But this is not that case, both for reasons of substance and for reasons of jurisdiction. This is not that case for the substantive reason that Bolivia's invocation of its claimed 19th century historic injustice is an appeal to sentiment. It is not an appeal to law, and it is flawed on the merits. This is not that case for the jurisdictional reason that matters settled by arrangement or governed by treaties in force at the point at which the Bogota Pact was concluded are outside the court's jurisdiction. Whatever view one might take of 19th century history, the 1904 Treaty of Peace and Amity drew a line under prior claims. These issues are not properly before the court. Mr. President, members of the court, I turn to my second topic, the broader picture, to give you a sense of what you are not seeing in the vision painted for you by Bolivia's council. For purposes of doing so, I will identify a number of elements that we think should properly inform the prism through which you should look at this case. Mr. President, members of the court, as you look at the exchanges of the parties over the years, it will be important that you see them not through the hindsight of judges and lawyers looking at the issues decades later, but rather through the contemporary lens of the politicians and diplomats who were engaged in the exchanges you are asked to assess. I do not mean by this to suggest that you should suspend your judicial role or character. Quite to the contrary, it is an exacting and forensic judicial inquiry that is required of this case. I mean rather that you should not check real-world diplomatic rationality and experience at the door when you engage in this exercise, as if somehow that experience is irrelevant. The diplomatic context is all important. Whether as a senior diplomat and representative of a state, as a foreign ministry legal advisor, as a politician, a key question running through the last decades of Chile-Bolivian relations is the following. When, on occasion, a representative of Bolivia comes knocking on your door and says, "We would like to talk about sovereign access," what do you say? What do you do? You might readily say, in the spirit of good neighborliness, or in the hope of that good neighborliness and something more concrete will emerge from such an engagement, you may readily say, "Sure, we would be happy to talk to you. You should have no expectations, as our territorial arrangements are governed by the 1904 treaty, but we would be happy to talk to you." Now, this happens the world over, in the great halls and margins of the UN or the OAS General Assemblies, when a non-paper is drafted and exchanged with a view to making more visible the contours of areas of potential agreement and disagreement, when political leaders agree to talk even on the basis of an agreed agenda, but all the while with an honest understanding that dialogue is not obligation, but rather an important step in seeing whether a problem can be resolved. This is the case here with the exchanges between Chile and Bolivia over the years. Chile does not disavow those exchanges, but it wants them to be seen for what they were. Political outreach, genuine and open, attempts to explore the possibilities for addressing relations between the parties, but not a commitment on Chile's part that Bolivia's aspirations would be met and that the discussions to be had were simply about the modalities of achieving Bolivia's aims. This is legal repackaging that neither reflects nor serves the reality of diplomatic intercourse. Mr. President, members of the court, as you reflect on the objective intention of Chilean politicians and diplomats when engaging with their Bolivian counterparts, there are two practical realities to bear in mind, practical diplomatic realities to bear in mind. The first is simply the very fact of the 1904 treaty and its long-arm controlling character on issues of territorial sovereignty between the two states. Treaties can be revised and new arrangements adopted if the parties so agree. But if you have a treaty such as the 1904 treaty, which settles issues of territorial sovereignty between the two states, the representative of one state may properly take comfort from the appreciation that the arrangements agreed in that treaty cannot simply be upset or revised by anything other than a subsequent express binding treaty-based commitment to adopt a different dispensation. In other words, the 1904 treaty is a backstop that secures your position and properly makes you more amenable to non-binding dialogue. The second diplomatic reality is an understanding, both diplomatic and legal, that diplomatic dialogue does not, without more, create binding legal obligations. This is what every diplomat knows in his or her bones. This is what the lawyers would have advised. This is what the politicians would have understood. The refrain, "Nothing is agreed until everything is agreed," is the most significant controlling phrase in any negotiation. There is no rational world in which any representative of a state enters into a dialogue with a counterpart from another state and says, "I'm happy to talk, Nothing is agreed until everything is agreed, but by way of an exception to this, I am happy to give you a cast-iron legally binding commitment up front that I will negotiate until you achieve your objective. But this is exactly what Bolivia is asking you to accept. Bolivia is asking you to accept that Chile, through its engagement and its conduct, manifested an open-ended, unconstrained, legally binding commitment to negotiate away a portion of its sovereign territory, with the only issue remaining to be addressed being the form of that gift of sovereign territory. Now, this is simply not credible. Mr. President, members of the Court, alongside these diplomatic realities, there are also other considerations that will inform the prism through which you ought properly to look at the case presented by Bolivia. The first of these is the settled legal framework of Chile-Bolivian relations regarding territorial sovereignty over more than a century preceding Bolivia's institution of these proceedings. I refer, of course, to the 1904 treaty. Now, I've already addressed the backstop quality of the 1904 treaty, but the treaty also has continuing relevance for wider purposes. And as the preliminary objections phase is 3 years away and the composition of the court has changed, I propose just very briefly to address one or two aspects of the 1904 treaty. The 1904 treaty was a definitive settlement of all issues of sovereignty. By Article 2, and you see the slide on the screen, the territories occupied by Chile by virtue of the Truce Pact of 1884, which brought the Pacific War to an end, are, quote, recognized as belonging absolutely and in perpetuity to Chile. There follows this brief extract on the screen from Article 2, a further 2.5 pages of dense text delimiting comprehensively the boundary between Chile and Bolivia. Now you can see on the slide on the screen this delimitation, which makes it clear that the entire boundary was delimited. There was no undelimited space, leaving room for what Bolivia now claims was a second stage concerning Bolivian sovereign access to the Pacific Ocean. The second stage is a Bolivian construct that finds no reflection in the 1904 treaty. Complementing the territorial settlement in Article 2 was the provision in Article 6 of the 1904 treaty, which you now see side by side with Article 2 on the screen, granting to Bolivia, quote, in perpetuity, the fullest and most unrestricted right of commercial transit through Chilean territory and ports on the Pacific, close quote. And this provision, Article 6, was supplemented by others which together established what was intended to be a comprehensive framework governing Chile-Bolivia relations going forward. And as will be evident as you look at Articles 2 and 6 on the screen side by side, the 1904 treaty settled the issue of Bolivia's access to the Pacific Ocean. And as I will come on to address more fully, as part of the 1904 treaty settlement, Bolivia abandoned any claim that it had sovereign access in favor of a treaty-based, that it abandoned any claim that it had sovereign access in favor of a treaty-based right of free transit in perpetuity. Bolivia, through its historical bargain argument, attempts to unpick the 1904 settlement, but it has no basis for doing so. Mr. President, members of the Court, together with the backstop quality of the 1904 treaty, the continuing relevance of the 1904 treaty for purposes of this merits hearing is that it effected a comprehensive territorial settlement between Chile and Bolivia and addressed definitively the issue of Bolivian access to the Pacific Ocean. The second consideration, relevant to a more complete perspective, is the evolving relationship between the parties on the ground based on the 1904 treaty. The 1904 treaty is the settled legal framework of Chile-Bolivian relations regarding territorial sovereignty, but it did not put in place a static regime. The parties have, over the years, undertaken and continue to this day to take active steps to enhance and secure the Article 6-based right of free transit to the Pacific granted to Bolivia. And these are addressed in some detail in Chile's counter-memorial. Now, we appreciate, of course, that Bolivia will seek to downplay these developments, but they are relevant nonetheless as they point to what the parties actually did over the course of decades and what can be deduced from this about Chile's intentions as regards any claimed commitment to negotiate sovereign access. Mr. President, Members of the court, the third consideration, relevant to a more complete perspective, is that for 53 of the last 56 years, Chile and Bolivia have not had diplomatic relations. Bolivia broke diplomatic relations with Chile in 1962, with relations remaining ruptured until 1975. Bolivia again broke diplomatic relations with Chile in 1978, and they remain ruptured to this day. Now, relations between Chile and Bolivia remain good at the people-to-people level, and Chile and Bolivia also continue to engage cooperatively on a wide range of matters, including on the enhancements to which I've just alluded concerning Bolivia's 1904 treaty-based right of free transit. But the absence of diplomatic relations is telling, because it is the clearest indicator that relations between Chile and Bolivia have not, for many decades, been conducive to commitments, however expressed, going to a binding obligation to negotiate to grant Bolivia sovereign access to the Pacific Ocean. Mr. President, members of the court, Bolivia has painted a partial picture for you which attempts to draw substance from the accretion of conduct between the parties over more than a century of engagement. The picture it tries to paint is of consistent conduct over this period. This is very far from reality. Dr. Juratovic will address this further in his submissions tomorrow. For the moment, I would like to leave you with a sense that it is important that you look both at the broader picture and at the details of the engagements between the parties. My colleagues will take you to the details. We believe that your clarity of vision will also be aided if you see this conduct through the broader lens that I have just proposed. Now, Mr. President, members of the court, let me turn to address the third of my topics, and that's Bolivia's claimed historical narrative. And we heard a great deal from Bolivia on this earlier in the week about its claimed historical bargain and its two pillars. The first pillar being Bolivia's cession to Chile of the territories lost in the Pacific War, and Bolivia's second claimed pillar, a cession of territory to Bolivia to afford its sovereign access to the ocean. Now, the difficulty with Bolivia's case is that it is pure fiction. It bears no resemblance to the well-documented historical record. There was no second part to the claimed bargain. It is historical revisionism in the face of the evidential record. Now, Bolivia raised the issue of a 19th century historical bargain in its reply. Chile addressed this argument in some detail in Chapter 3 of its rejoinder. But counsel for Bolivia seem not to have read this chapter at all, as they made no attempt whatever to engage with the evidential record set out therein. I will, in my few remarks to come, identify the main points, but in view of the weight that is placed on the historical bargain argument by Bolivia, I would invite you, members of the court, to undertake an early review of this chapter of Bolivia's rejoinder, as it will leave you in no doubt whatever that there is no foundation to Bolivia's historical bargain claim. Now, the genesis of its historical bargain argument is to be found in Bolivia's failed attempt to invoke the 1895 Transfer Treaty as a basis for an express obligation to negotiate. As set out in its memorial, Bolivia founded its claimed obligation to negotiate on the 1895 Transfer Treaty. And as stated in Bolivia's memorial, the 1895 Transfer Treaty, according to Bolivia, quote, created an international obligation for Chile to transfer a predefined area of territory, materializing a sovereign access to the sea for Bolivia, close quote. Now, the only difficulty with this assertion is that the 1895 Transfer Treaty never entered into force and was left wholly without effect, but a matter discreetly overlooked by Bolivia in its memorial. But the unconsummated status of the 1895 Transfer Treaty was acknowledged by the court in your preliminary objections judgment. That's at paragraph 16. But faced with the loss of the 1895 treaty as an instrument giving rise to a binding legal obligation, Bolivia had to invent. And its invention was its historical bargain argument that the 1895 transfer treaty, though wholly without effect, somehow nonetheless reflected a commitment by Chile to cede territory to grant Bolivia sovereign access to the ocean. Now, the record of the negotiations leading to the conclusion of the 1904 treaty, however, and informed contemporaneous commentary, leave no doubt whatever that Bolivia abandoned any aspiration to a port on the Pacific in favor of the arrangements that were ultimately agreed in the 1904 treaty. And we have good visibility into the negotiations that ultimately culminated in the conclusion of the 1904 treaty from Bolivia's own foreign ministry records, which Chile annexed to our rejoinder. So, for example, in a circular of the Ministry of Foreign Affairs of Bolivia to the legations of Bolivia abroad, dated the 25th of January 1901, we find the following comment, and I quote, "If Bolivia were to renounce its port, necessary as an indispensable condition for its progress and commercial development, it was required that Bolivia be provided with other means capable of making up the absence of a port, to be compensated as far as possible for the absence of a port, which Chile stated it could not grant to Bolivia," close quote. And then the following year, in a letter from the legation of Bolivia in Chile to the President of Bolivia, dated the 10th of April 1902, the core elements of what was to become the 1904 treaty were set out. And there is no reference anywhere to any claim by Bolivia to sovereign access, and no suggestion of a parallel initiative, what Bolivia now claims as a second part of its historical bargain to secure such access. In his book, addressing the history of diplomatic negotiations with Peru and Bolivia, Emilio Bello Codicido, the Chilean foreign minister who signed the 1904 treaty, and whom Bolivia invoked earlier this week, he records, quote, that the idea of offering to Bolivia an area with access to the sea was disregarded because it was impracticable, although it was a logical and legitimate aspiration, close quote. And importantly, he goes on to record that one of the items of negotiation that received particular treatment was, quote, Bolivia's abandonment of any aspiration to a port on the Pacific, close quote. And I emphasize this, Bolivia's abandonment of any aspiration to a port on the Pacific. The accommodation for the abandonment of Bolivia's sovereign access claim was the arrangements agreed in the 1904 treaty. Mr. President, members of the court, there is no basis to Bolivia's historical bargain claim. Bolivia's claim to a port was abandoned in favor of the arrangements that were ultimately agreed in the 1904 treaty. The 1904 treaty occupies the space. There was no second part waiting to be agreed. Now, Bolivia today may lament what their forebears did a century ago. But the history shows, in the words of Bolivia's foreign minister, Federico Diaz de Medina, in 1901, quote, that sensible men from both countries were engaged so that peace could be secured, close quote. Counsel for Bolivia may wish to conjure some hidden compact, but there was none. If Bolivia is to found its case for an obligation to negotiate, it must do so by reference to binding contemporary commitments, not to fictitious claims of a 19th century bargain. Mr. President, members of the court, I turn to some very, very brief concluding remarks on an argument that Bolivia did not make earlier in the week, but hinted at. More than once, Bolivia's counsel, referring to the exchanges between Chile and Bolivia, said that this conduct, whether taken separately or together, gave rise to a binding commitment to negotiate on Chile's part. Now, we heard very little from Bolivia on the detail of the legal basis for deducing a binding commitment from individual exchanges, but we heard nothing at all whatsoever from Bolivia on any theory of accumulation. And we presume from its silence that the whether taken separately or together refrain from Bolivia is simply that it is simply a refrain, and that Bolivia does not here advance an accumulation theory of argument. Certainly, no such argument has been developed with any particularity in Bolivia's written pleadings. Of course, we still have Bolivia's second round submissions to come, so we may yet be treated to a further iteration of Bolivia's case. Lest this issue be in the minds of the court, however, there are two very brief points that I would like to make. The first is that 0 plus 0 plus 0 equals 0. When it comes to founding a legal obligation, the whole is not greater than the sum of the parts. Bolivia cannot found a legal obligation to negotiate on conduct that invokes a series of engagements that, when individually assessed, are unable to sustain the claim that is advanced. Second, for there to be an overall pattern of conduct, there must, in fact, be a thread of consistent and continuous conduct that runs between all of the claimed exchanges, joining them together in cumulative effect. But there is no such thread in the exchanges that Bolivia seeks to stitch together. Now, I say no more about this other than to leave you with the proposition just stated, as Dr. Juratovic will address this aspect more fully in his submissions tomorrow. Mr. President, members of the court, that concludes my submissions. I thank you for your kind attention. And Mr. President, may I ask you to call Professor Jean-Marc Thiovenin to continue Chile submissions.
I thank you. Et je donne à présent la parole à Monsieur le Professeur Thiovenin. Vous avez la parole.
Merci beaucoup, Monsieur le Président. Monsieur le Président, Mesdames, Messieurs de la Cour, c'est un grand honneur de paraître devant vous pour présenter certains des arguments du Chili que je remercie vivement pour la confiance qu'il a bien voulu m'accorder. Il m'est choix de présenter la position du Chili sur les sources du droit international invoqué par la Bolivie comme fondement de la prétendue obligation qu'elle fait valoir, ainsi que sur le contenu d'une obligation de négocier lorsqu'elle existe et sur son extinction. Auparavant, je ferai 3 brèves observations sur la thèse bolivienne. La première, qui s'inscrit dans le prolongement des observations que Sir Daniel vient de faire, concerne l'obligation de négocier que la Bolivie prétend opposer au Chili dans la présente instance. Poupée russe ou cheval de Troie, le fait demeure. Ouvrez l'obligation de négocier, c'est une autre qui surgit. L'obligation pour le Chili de concéder un accès souverain à la mer, donc un droit pour la Bolivie de se voir concéder le dit accès. Or, Monsieur le Président, la Bolivie ne peut pas faire valoir une telle prétention devant vous. Votre Cour a soigneusement procédé à une interprétation de la demande bolivienne et a jugé que, je cite, « Dans sa requête, la Bolivie ne demande pas à la Cour de dire et juger qu'elle a droit à un accès souverain à la mer. » Fin de citation. Cette conclusion qui est à l'écran est essentielle à l'arrêt fixant les limites de la compétence que vous exercez dans la présente affaire, arrêt qui a expressément été rendu au vu de l'objet du différend tel que la Cour l'a défini. Dès lors, en droit, tout ce qui, dans les plaidoiries de la Bolivie, revient à réclamer que vous jugiez qu'elle a un droit à se voir concéder un accès à la mer, tout ce qui vous appelle à prédéterminer le résultat de toute négociation qui se tiendrait en conséquence d'une obligation de négocier, tout ce que vous avez expressément indiqué ne pas relever de votre compétence se qualifie comme une demande nouvelle, a new claim, qui modifie l'objet du différend, qui modifie l'objet du différend à l'égard duquel la Cour s'est jugée compétente. Cet aspect de la demande et les arguments qui l'accompagnent devraient donc être simplement ignorés par la Cour, car ils sont manifestement irrecevables. Ma deuxième observation porte sur la tonalité d'ensemble de l'argumentation bolivienne. Elle vise à créer de toutes pièces l'introuvable chaînon manquant de son dossier, à savoir une obligation juridique du Chili de négocier pour satisfaire l'aspiration bolivienne. Pour en donner l'illusion, la Bolivie a recours à diverses techniques de prétoire. Il y a évidemment la rhétorique que nos amis de l'autre côté de la barre manient avec un talent consommé. La Cour y est habituée et sait parfaitement faire la part du droit. Je dirais en revanche un mot de la technique favorite de nos contradicteurs, qui est celle de l'accumulation, la Bolivie essayant de faire masse de tout ce qu'elle trouve, d'inonder la Cour d'éléments de toute nature pour donner une impression de densité à une thèse qui n'en a strictement aucune. Je m'arrêterai à cet égard sur cette idée, développée pour la toute première fois devant vous lundi, que l'obligation de négocier dont vous êtes saisis découlerait non seulement d'accords, d'actes unilatéraux, etc., j'y reviendrai tout à l'heure, mais aussi de l'article 2, paragraphe 3 de la Charte des Nations Unies. Pour la Bolivie, la notion de différend contenue dans cet article viserait notamment toute situation, je cite, « where a problem is raised with a neighboring state and when the state declines to offer any reaction and refuses absolutely to address the matter at all. » Fin de citation. Il en découlerait, si l'on a bien suivi les explications du professeur Lowe, que puisque la Bolivie a fait connaître au Chili qu'elle a un besoin vital d'accès à la mer et que le Chili ne veut pas en discuter, alors il existe un différend, au sens de l'article 2, paragraphe 3, lequel génère l'obligation pour le Chili de négocier le dit besoin vital d'accès à la mer. 4 observations s'imposent. Premièrement, si cette formule était correcte, tout État pourrait, quand bon lui semblerait, obliger en droit ses voisins à négocier à propos de ses aspirations en faisant valoir qu'elles relèvent de ses besoins vitaux. Deuxièmement, le mot « négocier » n'apparaît nullement dans le texte de l'article 2, paragraphe 3 de la Charte, dont on nous dit pourtant qu'il génère une obligation de négocier. Troisièmement, la Cour aura peut-être été frustrée d'entendre lundi que sa jurisprudence à propos de la notion de différend est « irrelevant », car tout au contraire, elle est généralement, et à très juste titre, considérée comme ample, comme couvrant les différends en général, sans se limiter aux différends de nature juridique. Au demeurant, le caractère politique ou juridique d'un différend n'est pas une distinction matérielle, mais une distinction renvoyant au type d'argument et au champ lexical choisi par les parties. Un différend, au sens de l'article 2, paragraphe 3, n'est rien d'autre qu'un désaccord sur un point de droit ou de fait, une contradiction, une opposition de thèse juridique ou d'intérêt entre des parties, conformément à la jurisprudence Mavromatis. Le commentaire Simma, évoqué par mon éminent contradicteur, dont la contribution pertinente est signée de Christian Tomuschat, ne dit pas autre chose. Je cite, « A dispute arises when a state addresses specific claims to another state which the other state rejects. » Fin de citation. Le même auteur explique d'ailleurs, je le cite à nouveau, « Realistically, the Charter refrains from demanding of states that they should maintain with all of their neighbors relations of friendship and good neighborliness, although this is a desirable state of affairs. It confines itself to requiring all states not to let their dispute with other countries degenerate into a peace-threatening configuration. Fin de citation. Lorsqu'un État fait connaître à un autre ses aspirations, ses problèmes, et que ce dernier ne souhaite pas en discuter, il n'y a pas désaccord, contradiction ou opposition susceptible de faire naître une obligation, mais il y a sans doute une frustration. Monsieur le Président, Mesdames et Messieurs les juges, il n'existe pas en droit international d'obligation pour les États de négocier avec leurs voisins à propos de leurs aspirations. Ils peuvent le faire, ils le font bien souvent, mais ils n'y sont nullement obligés par la Charte des Nations Unies. La frustration de l'un ne fait pas naître l'obligation de l'autre. Quatrièmement, et en tout état de cause, contrairement à ce que suggère la Bolivie, le Chili n'a pas tourné le dos aux problèmes de son voisin. Depuis plus d'un siècle, le Chili a fait de constants efforts pour améliorer l'accès de la Bolivie à la mer dans le cadre du droit de transit concédé par le traité de 1904 et même au-delà de ses prescriptions. J'en viens à ma troisième observation, qui porte sur la prétention qui se trouve au cœur de la thèse bolivienne, qui est qu'un État serait soumis à une obligation de négocier dès lors qu'il se dirait disposé à entamer une négociation. Cette thèse est à vrai dire intenable après l'accueil réservé par les États à l'article 15, alinéa A du projet que la Commission du droit international a transmis en 1968 à la conférence diplomatique de Vienne qui devait adopter ce qui devint la Convention de Vienne sur le droit des traités. Il se lit ainsi. Un État est obligé de s'abstenir d'actes tendant à réduire à néant l'objet d'un traité envisagé lorsqu'il a accepté d'entrer en négociation en vue de la conclusion du traité, tant que ces négociations se poursuivent. Fin de citation. Ce texte a été rejeté par la conférence diplomatique, notamment, et c'est ce qui importe ici, parce que la plupart des participants se sont dit convaincus que, contrairement à ce que ce texte pouvait laisser penser, un État ne se lie aucunement lorsqu'il accepte d'entrer en négociation. L'opinion générale était, pour reprendre une formule de Paul Reuter, que, je cite, « Ouvrir une négociation n'engage à rien, car négocier répond à une action entièrement discrétionnaire. Jusqu'à la conclusion d'une négociation, le négociateur garde sa liberté totale, accepter, refuser, suspendre, rompre, en appeler à l'opinion, tout est permis. » Fin de citation. L'idée de modifier cet état des choses, comme le suggérait le projet de texte, fut rejetée comme contraire à la pratique et à l'opinio iuris, et jugée par ailleurs totalement inopportune, car l'adopter aurait eu pour effet, selon les États, de les dissuader d'entrer en négociation, minant le socle même des relations diplomatiques. Les visions catastrophiques dont le Chili est censé raffoler, selon le mot du professeur Ramiro Brotons, sont donc loin d'être les hallucinations qu'il suggère. À vrai dire, la Commission du droit international était elle-même convaincue qu'un État qui accepte d'entrer en négociation avec un autre n'est soumis à aucune obligation de négocier. Elle souhaitait seulement que fût indiqué que le principe de bonne foi impose une certaine conduite tant que des négociations sont en cours. Mais même cette précision, aussi peu engageante fût-elle, fut considérée par les États comme incompatibles avec leur liberté à l'endroit de négociations auxquelles ils ne sauraient être obligés pour la seule raison qu'ils auraient accepté de les entamer. Si vous me le permettez, Monsieur le Président, je vais maintenant vous entretenir des sources, des obligations sur lesquelles la demande bolivienne repose. Les professeurs Rémy Robrotons et Acavant me pardonneront de ne pas réfuter leur caricature de la position chilienne à ce sujet, qui relève d'une technique de prétoire bien connue, consistant à travestir les positions de la partie adverse pour mieux en dénoncer la prétendue inanité. Non sans quelques regrets, je ne disserterai pas non plus sur la notion d'atmosphère conventionnelle, si poétiquement évoquée par le professeur Rémy Robrotons. Mais le temps m'est compté et je vais donc me concentrer sur le droit. C'est une gageure de le faire, en quelques minutes, mais je vais m'y employer, car le demandeur convoque alternativement aussi bien que cumulativement quantité de figures du droit international. On échappe à la coutume locale, mais pas au principe général du droit international, puisque la Bolivie invoque l'obligation générale de négocier de la Charte des Nations Unies, que j'ai déjà écartée comme sans pertinence à l'instant. Voyons donc le reste. À commencer par l'accord. Qu'il soit explicite ou tacite, l'accord ne vaut que s'il reflète à la fois une rencontre de volontés identiques et réciproques entre les contractants et l'intention des États concernés de se lier juridiquement. Sans ces deux éléments, il n'y a pas d'obligation juridique. Le juge Rangev l'a très bien exprimé, et je le cite. La rencontre de volonté en soi ne suffit pas pour la création d'obligations juridiques. Il en est ainsi lorsque les parties à un accord n'ont pas voulu établir entre elles un rapport juridique et qu'elles ont entendu écarter leur volonté commune de l'espace couvert par le droit. Fin de citation. Cette exigence des deux éléments, rencontre de volonté et intention de se lier juridiquement, vaut bien entendu pour un échange de correspondances diplomatiques constitutif d'un traité. Ce type de traité suppose en principe que les parties se soient accordées sur les termes de leur engagement, afin d'exprimer leur volonté commune, avec la précision qui sied à un traité. Le glossaire des termes se rapportant au traité établi par les Nations Unies rend compte de cette pratique, bien connue du monde diplomatique, de la manière suivante. Je cite le glossaire. Le consentement des États à être liés par un traité peut être constitué par un échange de lettres ou un échange de notes. Dans la pratique, la deuxième lettre ou note, en général celle qui est envoyée en réponse, reproduira le texte de la première. Fin de citation. Dans ce contexte, une succession de notes dont la seconde ne reproduit pas le texte de la première rend généralement douteux qu'elle puisse être un traité. Mais à supposer même que, bien que différents, les termes des deux notes soient considérés comme reflétant fidèlement une identité de vue, ce qui suppose à tout le moins qu'elles parlent de la même chose. Encore faudrait-il, pour que leur échange soit porteur d'obligations internationales, qu'elles expriment une intention des parties de se lier juridiquement. On ne saurait le présumer, car bon nombre d'accords formels n'ont pas cette ambition. Tout dépend de l'intention exprimée par les parties, telle qu'elle ressort des mots qu'elles ont choisi d'employer. Si ces mots ne sont pas évocateurs d'obligations juridiques, alors ils caractériseront une posture purement politique. Lorsque telle est lorsque tel est le cas, l'accord relève de la catégorie bien connue des actes concertés non conventionnels ou, en anglais, des non-legally binding agreements. Monsieur le Président, ma langue a fourchu et peut-être que cela veut dire que c'est le moment de la pause.
Monsieur le professeur, la Cour va à présent marquer une pause de 15 minutes. L'audience est suspendue.